Welcome to the Business Owners Council, Legal Issues from Growth to Exit.
Welcome back to the Business Owners Council, Legal Issues from Growth to Exit. I'm Evan Mack, and in each episode we sit down with Kevin Brick, founder of Brick Business Law and trusted advisor to Florida companies, to talk through the strategies business owners need to grow, protect, and maximize the value of their business. Today we're talking about knowing the law versus knowing what happens, why experience changes litigation outcomes. Kevin, welcome, brother.
Thank you.
All right, so let's start here, Kevin. What's the difference between knowing the law and knowing how lawsuits actually play out?
Yeah, it's an important difference because knowing the laws is really about, what rules and statutes apply and what should happen in the case if it's just decided by the law. But in the real world, a lot of things actually affect the outcome of cases. If we think about the people who are involved, the different pressure points, the economics, and lawsuits are actually wholly or very significantly driven by those things: leverage, cost, the strength of the parties, who's the judge, the other factors like that. So knowledge of the law is very important, but it's really not enough to be able to give clients clear advice on how lawsuits will actually play out.
So why does the gap matter so much for business owners?
Well, a lot of business owners, when they understand that they're being sued or they have a lawsuit, their position is almost always, well, if I'm right or if I have a great case, I'm going to win. But that's really not the reality. And so if you have good counsel, they'll talk to you about things like the strength of the evidence matters more than what really actually happened, or, what you can prove, costs that go into a lawsuit and other factors that make it more just about the principle of it. A lot of winning cases too, they still end up with bad outcomes. So business owners in litigation, sometimes they're not seeing the complete picture when they're thinking, well, I have a great case or the law supports me.
Can you give an example of a case that looked like a clear win but wasn't really worth pursuing?
Just for an example, if you think about like a contract case, there's a strong legal claim in it, maybe, but for instance, it doesn't have an attorney's fees provision, or the defendant is not collectible. So a litigant may come into court and actually win the case, but the legal fees really undermine, if they can't win the legal fees, that undermines the outcome. Or if they get a judgment against somebody who's not collectible, it's kind of like you won in court, but the outcome isn't really what you wanted. So I think what really needs to happen is business owners and their lawyers should evaluate the return on the investment of litigation, look at factors outside of just the law and the merits of the case. And so as I said, lots of lawyers and business owners say, well, I can win this case, but you really have to take a holistic approach to counseling clients and making sure it's not just about, quote, winning the case, but actually getting to an outcome that makes sense for the client.
How often do you see business owners, overlook, collectability?
Yeah, it's a big thing, and it's very easy to do because you don't really often see the full picture of a litigant on the other side until after it's over. And so that idea of focusing on winning and not collecting, it's subtle, but it makes such a big difference. So people understand, I think, that getting a judgment doesn't equal getting paid cash. It's just a piece of paper that says, okay, the other party owes you money and you've got some legal rights to collect it. But there's a lot of ways things don't get collected. So, somebody on the other side of a lawsuit, they might not have assets. They might waste a bunch of assets knowing they're going to lose. They might hide them, protect them in some way. They might be able to delay payment, file bankruptcy, dissolve a business that's the actual party in the lawsuit. So to prepare for that, you have to have at least some plan to evaluate collectability early on as much as you can. And then, before you get into litigation, you should try to structure deals in some way that creates protections, secured interest or personal guarantees to the extent that you can do it. And then actually, as you're going through a lawsuit, you should try to assess if you think or if you can find out if there's been any changes with the potential collectability of the defendant or the litigant on the other side.
What's a real world example where the contract technically worked but failed in practice, though, Kevin?
Yeah, if you're thinking of a contract that's being litigated, it might be valid, it might be effective and enforceable, but maybe the terms are very vague. The scope of what has to be done, the deliverables, the timing, how it's enforced, and that leads to a legitimate dispute over the interpretation of it, and both sides have valid arguments. So the lesson there really is when you're drafting a contract, you do have to think about what's going to happen if this goes to court. So it has to be drafted not just for a legal structure, but also for clarity. If somebody else were to read it, how would they interpret it? And for enforcement, how do we actually enforce rights under this if things don't go the way we think they should?
So let's talk about, the sunk cost issue. What does it look like in litigation?
This happens. This is a dynamic I see a lot. So an owner spends a lot of money on a fees in a case, and they feel good about it, and they're pushing forward, and then maybe something goes wrong, right? And something they didn't anticipate, but they just feel so committed to continuing it because they've already spent so much money on the case in the past, and it just becomes this emotional decision where they're saying, "We've come this far, we're not going to give up now," or something along those lines. And so it's easy to fall into that trap, but the conversation, it should be something along the lines of, um, how does it look from this point forward? What is the expected return on investment from now forward? Because we can't undo the things that happened in the past. We shouldn't let the past, quote, the sunk costs dictate future decisions about how we're going to pursue a case.
What about the cases that drag on? How does time change the outcome?
Well, that's a significant issue. Is litigation. Fact is, it could take years to complete, especially my practice area, business litigation. The costs accumulate over time. It becomes frustrating. And one thing that people don't really think about is if your company or you are involved in litigation and it's ongoing for a long time, it's a lot of extra work maybe for you. There's a lot of distractions. Maybe your employees get subpoenaed and they've got to produce documents. And so there's all this extra energy that goes into cases that drag on. And that opportunity cost is real. You or your employees could be focusing on other things that build up the business. And so I think that the lesson that you learn about cases that drag on is you have to just reassess as you go. How long have we been in this? How much more time is it going to take? And what's the opportunity cost of doing something else or trying to get out of this at a certain point? And so that's an ongoing conversation that business owners should have with their lawyers. What is the timetable? What's the expectation? What can we do to make the timetable be more consistent with what we want it to be?
So what are the biggest mistakes that come from, relying on only, technical legal thinking?
Yeah, I mean that there's all these issues at play outside of kind of the technical legal part of the case. So ignoring kind of these issues that we've talked about already, the cost of litigation versus the potential for recovery, the timeline, as we talked about, having this overconfidence in legal positions that maybe the other side has arguments and positions that you haven't considered or that you are discounting. Missing out on opportunities, treating business litigation like it's a fight over principle rather than over more practical business decisions, and then just losing sight of goals. Right? Sometimes, if you're really focused on we should win because we have this argument, sometimes it just pulls you into losing sight of what are the real big business goals and how does this litigation fit into the bigger picture of what you want to accomplish.
So what do experienced business, attorneys, do differently?
Well, I think that they sit with their clients, their business owner clients especially, and they look at likely what is the investment of time, money, and effort into a case? What's the likelihood of different types of outcomes? Assess the practical realities of what you're putting into it versus what you're getting out of it. You anticipate things like, how is the opponent going to act? What are the pressure points? What are the opportunities to settle early versus going to trial? Having those discussions and early assessment of the case, and then to make sure that the strategy within the case actually aligns with the client's business goals.
How should a business owner evaluate, whether their lawyer is, thinking this way?
Well, I think it's about the quality of the conversations that they're having. Are they talking with their lawyer about things like potential return on the investment of legal fees in the case? What's the timeline? What's the strategy? Are they giving recommendations about different varieties of things that can be done? Does your lawyer understand your business priorities? Have you had those conversations? So one example might be, if you have a client that comes in and they have a very strong lawsuit, they want to pursue it. But at the same time, maybe they want to sell their business that year. The conversation should be, does it make sense to pursue that case right now when you're getting ready to sell? Because a lot of buyers, they don't want to buy a business that is in litigation. So having those conversations really high level about what makes sense for the client. That's really, I think, how you can tell whether you have a lawyer that's sort of the strategic advisor versus just a lawyer that's deep in the litigation piece of it.
What's the biggest mindset shift you want business owners to make, though, Kevin?
Well, one thing I think is that they should have practical conversations very early on. Don't some business owners, they walk into the lawyer's office and they think, I've got the best case. You're gonna love it. It's a slam dunk. I think that's the wrong approach. Really, one of the reasons you hire a lawyer is because they can give you strategic advice and assessment and help you come to the right outcomes. So I would say, be open to that advice and those conversations, and then let them help you reassess your risk, the cost, the actual opportunities that they see from their practical experience. And so all those things, I think, are a good mindset shift for owners who they may be just thinking win, 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 and probably they should be thinking strategically, how does this litigation fit into the bigger picture of my business strategy?
So what does a great outcome actually look like in litigation in your experience, Kevin?
A great outcome, it looks like the lawyer and the business owner, they're aligned on the goals, they know what they are, and then each step is actually moving towards those goals. A constant, practical assessment of how that's going, looking at the financials and the risks, trying to reduce business disruption, and then understanding the path forward. So all those things, I think, are factors to know that the outcome is going to be good, or it's likely to be good, or it's moving towards the best potential outcome.
Good stuff, Kevin. Thank you for your time, brother.
Thank you.
All right. That's it for today's episode of the Business Owners Council, Legal Issues from Growth to Exit. If you want to learn more about Kevin Brick and the team at Brick Business Law and what they can do for you, you can visit brickbusinesslaw.com. If you found this episode helpful, be sure to subscribe, leave a review, and share it with other business leaders who want to protect their companies and respond strategically when legal issues come up. Thank you so much, and we'll see you all next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.